Hello. So in continuance to our last lecture, we have to discuss what is the state under Article 12. So everything was fine, just not the word other authority. And then we have seen that how Supreme Court in cases after cases interpreting what is the state has broadened the concept of the state. So we have seen that how in University of Madras versus Shantabai, the interpretation was very conservative. But in Rajasthan Electricity Board versus Mohan Lal, the Supreme Court said that other authority under Article 12 should include all authorities created by the Constitution or other statute which are empowered by the law. And if they have the power to give punishment in case some people are violating their direction. So this was the principle held in the case of Rajasthan Electricity Board. Then in the last lecture I told you that in this lecture we are going to discuss further case laws on this Article 12, and I have to start with Sukhdev Singh versus Bhagat Ram 1975, and then I told you that this case along with Sabhaji Tiwari versus Union of India, they both were decided on the same date by the same bench. Still they have it has been decided differently. So how is that? Let's see. Now the primary question in Sukhdev Singh versus Bhagat Ram was whether ONGC, we know what is ONGC, PSU, private sector unit, public sector unit. So what is ONGC? Oil and Natural Gas Corporation, then IFC, International Finance Corporation, and LIC, Life Insurance Corporation, created by an act under the whether they are under the purview of state or not. So the primary question was whether these three bodies, ONGC, International Finance Corporation, and Life Insurance Corporation, which are created by a statute, are state or not. So this was the question. Now the Supreme Court, following the decision given in Rajasthan Electricity Board, decided that these bodies created by the statute and had a statutory power to make binding their decision, to make binding their rules and regulations, are state. So these bodies were held to be state because they all are created by the statute and they all have this power to punish anyone if they are not following rules and regulations or directions passed by these bodies. So with this, it was held that these three bodies are the state. Also, the Supreme Court added one more aspect to that Rajasthan Electricity Board principle, that is, it has to be, or the body, if it is a outcome of a statute or any act, and it is making the rules which are of binding nature, and it is acting as an agency and instrumentality of the state, then it will be the state. It means that if the body is doing some function which is actually governmental, then this is the state. So let me read this out for you. In Sukhdev Singh versus Bhagat Ram, it was held, statutory corporations are agencies or instrumentalities of the state carrying out the functions of trade and business, which on the other hand would have been carried out by the State Department. Hence, it must be seen whether a body is acting as an agency or instrumentality of the state. So this was the Sukhdev Singh versus Bhagat Ram case judgment. है ना? That is three things. It is outcome of a statute or act. It is making some rules and regulations which are of binding nature, and also it is functioning. It has some functions of state, that is governmental functions, or maybe it is functioning as an agency or instrumentality of the state. So this was held in Sukhdev Singh versus Bhagat Ram. Now on the same date, the same bench is deciding differently in Sabhajit Tiwari versus Union of India. In this case, it was asked whether Council of Industrial and Scientific Research, that is CISR, is a state or not. Now, surprisingly here, the same bench is saying that the body is not a state because it is registered under a statute and not performing essential state function. So, what's the difference? See, those three bodies, LIC, International Finance Corporation, and ONGC, these three bodies were created by a statute, है ना? And this principle we followed in Rajasthan Electricity Board also. But here when we talk about CISR, the thing is, it is not the outcome of a statute, but it is a body which is registered under some other statute. So it is not like that statute is providing this body or creating this body. Rather, this statute is only giving this body a registration. So this body CISR is registered under this statute, not the creation of this statute. है ना? So here the court is saying that this CISR is not a statutory body. It has only taken the registration from this statute, है ना? And it is also not functioning any essential state function. That's why it is not a state. है ना? So in Sukhdev Singh case, the court held that the corporation was a state as they are created by a statute, and also they were performing state function as well as they had pervasive control of government at this third one. है ना? This was the new in Sukhdev case. That is, they are the creation of a statute, plus they have important state function, and then they have pervasive state control. That is, the government or state is controlling in their functioning and operationability. So that's why they are a state. So in Sabhajit Tiwari, CISR was held not to be a state. And in Sukhdev Singh, these three bodies, LIC, IFC and ONGC, were held to be a state. Now, see what happened in UP State Warehousing Corporation versus Vijay Narayan, 1980. Now, after 5 years, again a case law come asking for a particular body, that whether this body is a state or not. Now, see what the Supreme Court is saying. In this case, what happened? That against an employee of a particular body, and the body's name is UP State Warehousing Corporation. One of the employee of this warehousing corporation was accused of false charges, that is charges of theft and misappropriation, and this employee was not even given a chance of fair hearing and was actually dismissed from the service. So this employee went to the High Court, there it was rejected, then he went to the Supreme Court. Supreme Court said that the Uttar Pradesh State Warehousing Corporation is a state because it was established under an act. It was held to be an instrumentality of the state as it controls and ownership were with the state. So the state is having control and ownership of this UP State Warehousing Corporation, in addition to this fact that this body is the creation of a statute. This body has been created by a statute. So because of these two things, that is, state is having pervasive control and it is the outcome of a statute. Because of these two things, this body is obviously the state. So the employee who was not given a fair chance of hearing and was dismissed of his service is this thing is a violation of his fundamental right. Okay, so this was the judgment in this case. Now come to a very important case law, that is R.D. Shetty versus International Airport Authority of India. You can note it down. Ramana Dayaram Shetty versus International Airport Authority of India. what happened in this case? Let's first understand the fact of this case. Now what happened? This International Airport Authority. This authority issued a notice in the year 1977 for inviting registered second class hotelier having at least 5 years of experience for putting up and running a second class restaurant and 2 bars at Bombay Airport for a period of 3 years. So this was the notice that for a period of 3 years to run a second class restaurant and also 2 bars at Bombay Airport, we are inviting tenders of those people who have at least 5 years of experience in this second class hotelier. ठीक है, अब ये हुआ. So 6 tenders were received in response of this notice. 6 tenders. Now what happened? The International Airport Authority only admitted 1 tender, and this tender was what can I say? This tender was admitted because it was complete and also it was offering the highest amount of license fees. So in that tender it was mentioned that we are going to pay maybe 10 lakh, 12 lakh, and which was the highest as comparison to the other people who are applying for the tender and as a license fees. So this was selected. Now other people, obviously they were questioning that even our tender was complete, so why were we not even given a chance to present, है ना? क्यों नहीं मिला? सीधे इसको ही क्यों मिल गया? So anyways, what happened? This R.D. Shetty, he was not the one person who gave any tender. He is totally a third party. He filed a suit in the High Court of Bombay by challenging the decision of accepting the tender of only one person, and in this case this person is the 4th respondent, है ना? And obviously this was dismissed in High Court. Ultimately R.D. Shetty came to Supreme Court, है ना? Approached Supreme Court. There the Supreme Court finally determined whether a body is a state under Article 12 is not. Now it is very important to always remember this 5 points, because in R.D. Shetty case, Supreme Court is finally laying down some kind of substantial provision, substantial principles. ठीक है? So what are this? Supreme Court is saying that Supreme Court is laying down some rules and tests to know whether a particular body is a state or not. So the first one is the financial assistance given by the state and magnitude of such assistance. So it is not that the state is giving some fund, इतना तो donation भी दे देते, कुछ कर देते हैं, but the magnitude also. If a major part of the share, a major part of financial supporting is coming from the state, then it is obviously a body of the state. It's a part of the state, है ना? So the financial assistance and the magnitude of such assistance. Then any other kind of assistance, whether of the usual kind of extraordinary. So sometimes not just financial assistance, sometimes the state is sending its official to work in that particular organization. Sometimes the state is maybe framing some policies and programs only for that body, है ना? So not just financial assistance but any kind of usual or extraordinary assistance, if it is there, then you can say that it is a state. But in addition to this, control of management and policies of the corporation by the state. That is the nature and extent of control. If this body, maybe it is ONGC, maybe it is UP warehousing, जो भी है, if this body is totally controlled by the state only, then obviously this is also a state, है ना? Then the state conferred or the state protected monopoly status. So if the state has given monopoly status, for example LIC is one of its kind. Airport Authority of India, the present case, there is no other body like this. There is only one Airport Authority of India. It is a government's body to regulate the matter related to aviation and this airports. And obviously financially it is dependent on state, top management is by the state, so all kind of assistance is by state only. So how come you can say that this is not a state? So and it has also given monopoly status. So if it has a monopoly status, and also the function carried out by the corporation, whether public function closely related to the government function, would ascertain whether a corporation is instrumentality or agency. So what this body is functioning, governmental function, instrumentality function or kya? So, or if one of the department of the body is transferred to the government, है ना? If these 6 points are there, then you can say that this is the state. Okay. So with this state, it was held by the Supreme Court that International Airport Authority is undoubtedly an instrumentality and agency of the central government and falls within the meaning of Article 12, that is the state. है ना? So the court tried to conclude here by saying that just as government acting through its officer is subject to constitutional and public law, similarly, government acting through its agencies, its companies, its corporation is subject to the same level of restrictions. है ना? So this is the judgment in R.T. Shetty versus International Airport Authority of India. The year is 1979. Now we have another case law in row, that is Som Prakash Rekhi versus Union of India. And this in this case, it was asked whether Indian Petroleum Corporation is a state or not. What happened here? That in this case, the fact of this case is like pension of some employees, some ex-employees. Pension of some ex-employees were all of a sudden reduced, even without informing those employees by the central government, because this body was later transferred to the central government. So the pensions were reduced. So this thing was challenged before the Supreme Court of India, that even without informing us, this body has reduced our pension. So our right has been violated. So what the Supreme Court is saying? Supreme Court is saying that surely Indian Petroleum Corporation is a state and your right has been violated. Merely because a legal corporation has its own legal identity does not mean that it is not an agency or instrumentality of a state. So IPC, Indian Petroleum Corporation, even though it's a company, but still it is the state, because all the functions are taken care by the government only, na? That's why it's a state. And Supreme Court is saying in this case, a public authority is a body that perform public function or which perform duties and carries out a transaction for the benefit of the state. So it is defining public authority in such a way that it is a body that performs public function and performs its duty for the benefit of the state. In this case, Indian Petroleum Corporation is doing this. That's why it's a state. Then next case we have Ajay Hashria versus Khalid Mujib. The year is 1981. Again, very important case. What happened in this case? So actually the facts are like this. Admissions, it is related to admissions made in the Regional Engineering College, Srinagar, for the academic year 1979 to 1980. है ना? So this was related to this. Now what happened? That the college, this regional college, obviously is the government kind of college, regional college. So the college was established, administered and managed by the state, by a society, है ना? And this society is registered under Jammu and Kashmir Registration of Societies Act 1898. So this college is established, administered and managed by a society, and this society has been registered under an act. ठीक है, इफ यू रिमेंबर CISR वाला केस है, that particular body was registered in a act. The same thing is coming here, है ना. Now what happened? So the admission was like, there was a examination, and examination was like 100 marks for written test, 50 marks for oral test. So this admission test were conducted. Now what happened? Few of the applicants or candidates observed that they have received highest good marks in written test, but they have not received, or they have received very few marks in interview. And also they noticed that these people, when they were interviewing us people, then on an average they took only 2 to 3 minutes in our interview. It was just like a formality, है ना. And in the result we can see, in the final result, that we got good marks in written test and got less marks in interview. That too, they only gave us 2 to 3 minutes, and few people who got very few marks in the written test out of 100 got very good marks in Viva voice, and now have been admitted in the college. They got the admission. So these people approached the court for discrimination. That is, the college has discriminated against them. Now what the court is saying? This case is not very liberal in interpretation, as like in University of Madras versus Shantabai, है ना. In this case it's not very pro state interpretation, but ठीक है, this will be overruled soon, so don't worry for long. So what happened? The Supreme Court saying the first thing to ascertain was whether a college that was established by the registered society is a state under Article 12 or not. This was the first question before Supreme Court. And the Supreme Court said the society was held to be a state as it was an agent of the state. A constitution bench of this court, while approving the test, court approved those tests, held that in this present case, these tests are not final and not conclusive in nature. It is also to be noted, Supreme Court is saying, it is also to be noted that it cannot include every autonomous body which has some connection with the government as a state, है ना. So the verdict was not very clear. One thing is clear, that those tests were held valid, ठीक है. But ठीक है, कोई बात नहीं. We have this Pradeep Kumar Vishwas case which overruled the decision of Ajay Hasia case. Now what happened here? Pradeep Kumar Vishwas versus Indian Institute of Chemical Biology, year is 2000. In this case, actually this case is used as a precedent for the further case, and it overruled Ajay Hasia's case. And in this case, the court is saying that there is no strict rule that a registered societies having any connection with the government in every case to be considered as a state. So उसने बोला ठीक है, every case में नहीं होगा. But in this case, Pradeep Kumar Vishwas, again this question was discussed, that whether CSIR was an instrumentality of the state within the meaning of 12 or not, है ना. Then, or if the answer is yes, the Supreme Court should reverse the decision to the contrary in the Sabhijit Tiwari case. In Sabhijit Tiwari case, it was held na CSIR is not a state. So if in present case it is decided that this is a state, so whether the Supreme Court should reverse the decision in Sabhijit Tiwari case, which had stood up for a long period now, क्या होगा अब देखते हैं. तो in this present case of Pradeep Kumar Vishwas, it was held that CSIR is an instrumentality of the state and will be amenable to the writ jurisdiction under Article 12, है ना. So this case actually reversed or overruled Sabhajit Tiwari case. So this is this. Now a very recent case, even this recent case is 10 years old, that is Dr. Janet Jayapal versus SRM University. We all know SRM University. In this case it was asked whether SRM University is a state or not. अब देखो how much this jurisprudence has been developed. The very first case started with questioning whether University of Madras, which is a government university, is a state or not. In that case, even a government university was held that it is not a state. And now see how in 2015 a petitioner came before the court asking whether this private university SRM is a state or not. And see how Supreme Court is beautifully saying that SRM University is engaged in imparting higher education in various subjects, and it is a deemed university under UGC Act 1956, है ना? And it follows all the norms of UGC and other bodies, hence it is a state. The Supreme Court held that SRM University to be a state because it's a deemed university under UGC NET and it is imparting higher education, which is a state function. That's why it is a state under Article 12, है ना? And then also we have another case law, that is whether BCCI, you all know, if you are a cricket lover, what is BCCI, whether BCCI is a state or not. So in the case law of Z Telefilms versus Union of India, it was held taking Ajay Hashia's and Pradeep's cases into consideration that BCCI is not a state. उसको state नहीं बोला क्योंकि it is not performing a governmental or state function, तो नहीं है ये. And finally, a question of our importance, whether judiciary is a state or not. So this is the last thing in this discussion, whether judiciary is a state or not. Now, the first case on this is, that is Naresh Sridhar Mirajkar versus State of Maharashtra. This is the first case where Supreme Court decided whether Supreme Court or judiciary is a state or not. And Supreme Court observed that if the court decides that the court is a state, then writ cannot be issued under Article 32, that is constitutional remedy, against its order and its judgment, as such orders or judgment violate the fundamental right of citizen. But finally, in the case of A.R. Antule versus R.S. Nayak in the year 1988, the Supreme Court said that the court could not give such order and direction which violates the fundamental right of the citizen, है ना? So even the Supreme Court cannot, or any judiciary cannot pass any kind of order or decision which violates the fundamental right of a citizen. So finally it has been concluded from the judiciary, from these cases, that judiciary is considered as a state while it performing legislative and executive function, that is appointment of judges and appointment of judges of Supreme Court and High Court, and is not a state while performing its judicial function. ठीक है? So judiciary while performing legislative and administrative function is the state. Judiciary while performing its own function, that is judicial function, is not a state. This is the present situation. And with this, our Article 12 is completed, and these are the minimum case laws which you have to read to explain what is Article 12, है ना? And you can add on and on, that's your choice. Thank you so much.